Hey Zach,
Hey Ron.
how you doing?
Good, good.
You had some questions on loan modifications?
Yes, I did. So what exactly is a loan modification?
Alright, well, you approach your bank and you tell them that you want to work something out with them where you're changing your payment terms. Most debtors, their goal is to lower their monthly payment, which could come a number of different ways. It could be spreading out terms, meaning let's say you're 5 years into a 30-year and it's redone so that it's stretched out for another 30-year term. Let's say the interest rate is modified. A combination of things that the lender could do for you so that your monthly payment goes down. That's typically what folks are striving for with a loan modification.
Okay. Now, does the borrower need to be in default in order to apply for a loan modification?
No. If you're current on your payments and you wish to apply for a loan modification, that's possible. I know recently I've heard a lot of talk about, I've heard people saying miss a couple payments so that the lender will work with you. There may be some truth to that, because if you're several months behind, the lender's thinking, do I put them into foreclosure? Do I work with them on a loan modification? You've kind of turned up the heat on your lender.
Mm-hmm.
So arguably it seems to me there would be some truth to that, but is that a mandatory thing? No.
Okay. So can anyone get a loan modification?
Not anyone. There are certain requirements. It's important that you look to your current lender and find out what their requirements are. There's different programs also. For example, there's this HAMP program, H-A-M-P, where you can apply for a loan modification as long as you have certain requirements. For example, one of the requirements is a 31% of your income number. It's a bit more complicated than this, but basically you take your gross income and you calculate out 31% of that. And if your mortgage exceeds that, then you're someone that would fall into the HAMP category. Again, there's other criteria.
Right.
And then if you qualify for that plan, typically what you do is you get a series of 4 payments, which are considered trial payments. And then the lender looks to see that you make those trial payments on time. And if you do, then they go into a modification, and the modification would typically last for the rest of the duration of the loan. There's other types of programs too besides HAMPs. Some lenders will have you do a hardship loan. I had one recently where an individual had a first mortgage and a second mortgage. On his first mortgage he already had a modification, so he already was given a break on that. And the lender bundled in the taxes and bundled in the insurance, so the monthly payment he was making was just over $1,000, which included the tax and the insurance. But he had a second mortgage, and the second mortgage was a higher rate of interest. And between the first and the second, all that bundled in together, it was tough for him to make the payment. So what we did was we applied, and this happened to be through Citibank, we applied for a hardship loan through the second mortgage, and Citibank agreed to lower the interest rate and change the terms so that his monthly payment did go down on that. So there are a number of different programs that are available.
Good for him. Now, how does a bankruptcy factor into a loan modification?
There's a lot of misconception in that area, and sadly, because there's different reactions that you get from different lenders. I've had situations where people were already in some kind of loan modification arrangement with a lender, and they've already signed a deal, they were already into payments, they were current on the new deal, everybody was happy, at least in that regard, and then they needed to file bankruptcy for other issues like $100,000 worth of credit card debt or whatever. And when they applied for the bankruptcy, some lenders will blow up the underlying agreement and make a motion to lift the stay and look to get the right to foreclose on a property. They do that under the guise that since the person was in a loan modification, they were initially in breach. And despite the new agreement and the fact that they were current with the new agreement, they take the position, well, you weren't really current. So that puts pressure on the homeowner to work something out with the lender. And what does that mean? That could be a whole host of things. Just because a lender files a lift stay motion, that means a motion to lift the stay to be able to pierce into the bankruptcy, and then be able to take the mortgage protection from a bankruptcy and then be able to go after you in a state court if they wanted to. It doesn't mean they're going to.
Right.
They're putting pressure, obviously, on the debtor to square up. And another thing too is that there's remedies. You can answer to it, and you could respond through the bankruptcy court once you file bankruptcy that you're trying to work something out. You can actually arrange hearings with the judge to push back against the lender. In our area, in the Eastern District, there's one of the 3 judges that actually has a loss mitigation program that you can get involved with, where you can push back against the lender, and the judge can actually help you put some pressure on the lender to work with you and get a loan back on track. At the end of the day, the mortgage company doesn't want to foreclose on something where they're going to get payments. So the name of the game is continuing to show them whether you're going to get the payments. If you need to work out some kind of modification program that works for both the lender and for the debtor, you strive to try to find that happy medium. And the judge will typically give you time and work with you to help you work with the lender to work something out, and that's what obviously everybody's striving for.
All right. Well, thanks a lot, Ron.
All right, Zach. Talk to you later.